Morning, Scott.
Oh, all right.
Can I just ask everyone to pop themselves on mute? I'm getting quite a lot of background noise through. That's better, thank you. So I wanted to start today off with, I guess, why does employment status matter and what's the implications if you get it wrong? Just to put a bit of context to the legal framework that we're going to be discussing. So I've just got a few key, there's a whole host of reasons, but just a few key reasons here on this slide about why getting employment status right actually does matter to you and your organisation. So the first one there is that in an employment relationship, when there's an employment contract, there's actually implied terms within that employment contract that aren't going to be a feature of a contract for services and perhaps arrangements for a worker or a self-employed person. The most kind of obvious one that I'm thinking of with that is the implied term of trust and confidence. So it's just worth noting that when you have an employee and an employment relationship, you're going to have more than just the express terms in that contract. There's all these overarching implied terms that will be applicable in that relationship. And as well, it's important to know because some legal protection only applies to employees. So two of the biggest ones there is that the ACAS code and disciplinary and grievance procedures applies to employees. So that's not going to be something that's binding if you're dealing with someone who's a worker or someone who's self-employed, legally speaking. And also in 2P transfers, those regulations kick in if you're dealing with groups of employees. So if they're not meeting that employment status, again, that's relevant. For tax treatment as well, employment status is quite central there. Depending on what classification of employment status the individual is, there's going to be impact on the tax for the individual and implications for the organisation. You'll need to have a determination on status to know if the off-payroll working rules apply. If someone's self-employed, they're more likely to be responsible for their own tax in arranging that themselves, compared to if they're employed. So again, it's worth knowing that if you get that wrong, you could be in a bit of hot water with HMRC as well as employment law implications. For vicarious liability, just worth noting as well that employers can have liability for the actions of their employees, whereas the rules there differ if they're workers or if they're self-employed. And that can be in terms of discrimination in employment law, any discriminatory acts carried out by an employee. And as well, it can be in the law of delict, which would be more so civil liability if one of your employees breaches their duty of care on anything. So it creeps in there. As well for insurance, because employers will usually take out employers' liability insurance, a minimum of, I'm sure, 5 million. And that will be used to pay out employees in the event of any sort of injury at work. But if you have any workers or independent contractors, they might not be captured by that insurance, and that might be something that you want to discuss with them, and they might want to consider entering into their own appropriate insurance because they're not captured there. And everyone's favourite, GDPR. So we can see there that employment status actually does have an impact on GDPR and these regulations. The reason being that if someone's a self-employed independent contractor, they might have specific process and obligations, and the ICO, who set the guidance for how the UK GDPR should be used in practice, actually have their own guidance, which if anyone's interested in, I can send them after. They have their own specific guidance for data processing for self-employed contractors, and that's obviously going to be different to the way an employee will utilise a GDPR policy. So just some things to think about of the different areas that employment status can really permeate into. And our next slide, I suppose before getting into the legal framework, I just wanted to make the language that I'm going to be using clear. So you'll see in these circles here, all different types of words, words of individuals I'm sure you'll likely engage. You might use different terminology. So we've got things like temp, 0 hours, casual, freelance, self-employed, agency worker. And I guess what I just really want to make clear for the purposes of today is that although there's all these different labels, there only is 3 legal employment statuses, and I've put them in the squares below. So that's an employee, a worker, or a self-employed person. And all of these will fit in to the 3 legal employment statuses. So today in the case law and in the legislation, we're going to be talking about these 3 terms here. And also worth pointing out that although they can neatly fit in, sometimes it can be a bit more complex. So you could have a 0 hours worker who fits into the worker status, but also they could be an employee. You could have someone who's engaged on a casual basis, who fits neatly into a worker. If that firms up a bit and becomes the relationship changes, they could creep up into employee status. So it's worth noting that it's a bit more fluid than that. The labels don't automatically indicate they belong to any one category, and that's what we're kind of going to get into today. So just starting off with the first of those 3 employment statuses is an employee, and that's really defined in statute in the Employment Rights Act. And it's quite simple. The definition given is just an individual who's entered into or works under a contract of employment. So we're really looking for someone who works under that contract of employment, and they define a contract of employment later on in that section as a contract of service or apprenticeship, whether express or implied, and whether oral and in writing. And although this sounds quite complex, we can see there that it doesn't actually need to be a written contract. The Act makes provision for it being an oral agreement, and it is important to kind of know whether this is a contract of employment, because an employee will receive the most enhanced employment rights of any of the 3 employment statuses. So they will have a right to receive redundancy pay. If they're over that 2-year mark, they'll have protection from unfair dismissal. They can make they have a right to written in particular their employment. If they're leaving employment, if the contract's coming to an end, they have a right to a notice period as well as to notice pay. They have statutory sick pay. They've got a whole host of statutory family pay, whether that be maternity, paternity, adoption. They also have additional rights like the right to request flexible working. So we can see that they have more employment rights, and that's often where a dispute will creep up, because, for example, someone who's classified as a worker might think, wait a minute, I want to request flexible working. I'm looking at the relationship. I think I'm more in line with an employee, not a worker. Or quite often it can relate to pay, a pay that a specific group's entitled to, that individual's not entitled to, and that's where dispute can kind of kick in, which we'll look at more closely when we look at the case law. So a worker is a more broad category, and again, it's set out in the Employment Rights Act. So it's someone who doesn't have a contract of employment, but they still have some sort of agreement to perform work or services for an organisation. So that does sound quite broad. So I've kind of picked out some working examples that hopefully put a bit of context to that. So that could be an agency worker, whereby the agency finds their work and pays their wages, but they do work for that organisation. A short-term worker who could be hired directly by the employer, and supply their services to the employer on an irregular or casual basis. It could be someone who's freelance, and I found this example quite interesting because someone who's self-employed for tax purposes could still be classified as a worker for employment rights purposes, depending on the reality of that arrangement. That's just some examples of who would fit into this category of a worker. And they do have some rights in employment law, but it doesn't extend, and it's not as expansive as the rights of an employee. So some of them include the right to be paid national minimum wage and protection from discrimination and to some holiday pay. So again, quite often disputes can arise, and you'll see there they have the right to be paid national minimum wage and holiday pay. So if someone's classified as a self-employed contractor and they've not received the right payment in terms of these payments, a dispute can arise there of, I'm not actually self-employed, I believe I fit more neatly into this worker category. And I've just copy and pasted straight from the statute the definition of a worker. And you'll see that it's got two limbs. So an individual who's entered into or works under a contract of employment. So that has the kind of impact of everyone who's an employee is also a worker. But B, limb B, any other contract, whether express or implied, and whether oral or in writing, whereby the individual undertakes to do or perform personally any work or services for another party to the contract whose status is not by virtue of the contract that of a client or customer of any professional or business undertaking carried on by the individual. So that limb B, that definition there is where more of the scrutiny by the courts and the employment tribunal will creep in. And just again, to give that some practical context, I've looked out some key indicators of whether someone would be a worker. So some or all of these might be applicable, and hopefully that helps put some context to what that wordy statute actually means. So some key indicators would be that there's an arrangement or contract to personally undertake work or services for a reward. And quite often buzzwords in these types of contracts will be casual or as and when required. There's no requirement for work to be offered or accepted. So in essence, they work when they want. There could be no regular or guaranteed hours. So usually in an employment contract, you'll have a clause where it says you're contracted to work 25 hours per week. In this type of contract, it's more common that it will not be worded in such a way. They're required to do the work themselves. Having accepted their work, the employer will be in charge of how, when, and where they work, which we'll get into a bit later. The business will usually provide tools, materials, and uniforms, and tax and NI will be deducted from wages. So that's just some useful key indicators. That if some of them are true, if all, it would usually point towards that individual being a worker. And some of that's derived from the case law we'll discuss later as well. So the last category I just want to talk about before moving on to some of the more practical things is the final category of self-employed. And this is the category that comes with the least amount of employment rights. Usually self-employed individuals work for themselves and take responsibility for managing their own business. And often this can take the form of self-employed contractors who provide their services via their own personal service company, of which is usually a limited company and they're the sole shareholder. So that's an arrangement that I see quite often being used by engineering companies. Usually they're engaged through an agency or an intermediary and supplied to the organisation thereafter. They'll usually deal with their own tax and insurance. That will be a responsibility of the organisation. And the limited protections offered to them will be against discrimination, some health and safety protection from rights and responsibilities that will usually be set out in the terms of the contract. So a lot of the relationship and the rights that they have will come from the actual contract of service that they have with the client, rather than derived from employment law. So it's the most limited. And again, I found this kind of useful. This is from government guidance, so from the UK government, and it's a page that's designed to help employers identify if someone's self-employed. And they've given this kind of helpful list. Again, kind of key indicators similar to what I'd collated for the worker status. So it says someone's probably self-employed if they're self-employed for tax purposes, and most of the following is true. So it says they put bids in or give quotes to get work. They're not under direct supervision when working. They submit invoices for work when they've done. They're responsible for paying their own national insurance and tax. They do not get holiday or sick pay when they're not working. And they operate under a contract, sometimes known as a contract for services or consultancy agreement, that uses terms like self-employed, consultant, or independent contractor. So that's the government's guidance on key indicators for a self-employed individual. So now we've kind of looked in a bit of detail about each of the employment statuses. I really want to focus on how we determine someone's employment status and the tools used by courts and tribunals in cases where there's been a dispute, when someone's disputing the status that their employer's attached to them. So the kind of key thing is that courts will and tribunals will actually look beyond what's written down. So quite often you'll see a contract and they've signed a contract to say, I agree that for the purposes of employment status, I am a worker, or I am self-employed, or I'm aware I'm not an employee. Some sort of wording. But that doesn't offer complete protection, because what the courts and tribunals are interested in is looking beyond what's written down, what they've signed, and the reality of the relationship between the individual and the organisation. And they're wanting to try and weed out any sham agreements that are designed by employers to essentially cover up the true nature of the relationship and avoid giving employment rights. So they want to try and stop that from happening, stop that practice. So, but as well with sham agreements, I think a good example is quite often there'll be certain terms that point towards someone being self-employed or someone being a worker as well. So whether that be you would never see in an employment contract any sort of substitution right. So if that person can't do the work, someone else can come and do it. So they can put that in an employment contract, in a contract. It could really mirror an employment relationship, but because that's in, it really points towards them being self-employed. So that's if they couldn't do that in practice, if it says in the agreement, yeah, you can substitute, someone else can do the work for you, but they don't do that in practice. That's a good depiction of what a kind of sham agreement would be. Just wanted to mention the irreducible minimum, which is a tool used by the tribunal when they're making a determination on the true nature of an agreement. So we've got three elements to that, which they will apply when looking at a relationship and an arrangement. The first being personal service and substitution rights, which refers to only in extremely limited and exceptional circumstances an employee and worker is required to provide personal service, whereas it would be consistent with an independent contractor to be able to provide a substitute. So that's what I just spoke about in that example before. You'd be looking at whether they have to provide that service personally, and whether there's any true right to just substitute and get someone in to subcontract that work. The second is control. So that there needs to be some element of control, and quite often they refer to a control test. And one of the kind of most famous employment status cases, Ready Mix Concrete. I think they summed that control element up quite well. And they said control includes the power of deciding the thing to be done, the way in which it shall be done, the means to be employed in doing it, the time and the place where it shall be done. So they'll look at how much control the organisation has over these elements, and that usually is a good indicator of the minimum required to be an employment relationship. And the third there is mutuality of obligations. And that's when there needs to be some sort of ongoing obligation on the organisation, the employer, to provide work and pay, and an obligation on an individual to accept work and perform that work. So it's a kind of ongoing obligation on the other, one to provide work and one to accept. And that's usually really common of an employment relationship, because as we discussed when we looked at workers and self-employed individuals, they don't usually have that constant need to accept work. They can work as and when required. So that's another key thing they'll look at when trying to determine if it's an employment relationship. And a lot of this is quite heavy legal principles, so I picked out in the next few slides, just to finish us off today, some key case law which shows how they speak about this and the way cases have been decided in the past. So a lot of these cases are really fact heavy, so if any of them are particularly interesting to you, I urge you to go and read them. They are really interesting, but I've tried to pick out the key facts and kind of takeaways from each case. So the first case is Auto Cleanse Limited against Belcher and others. And in this case, it was car valuers. They worked for Auto Cleanse, and they wanted a declaration from the tribunal that they were actually workers and not self-employed contractors, as the agreement they signed stated they were. In terms of control, they had no control over the hours they worked, and deductions were made from their pay for insurance and materials, and they had no say-so on where the materials were bought or the price of them. They just came off their pay. The written agreement that set out the relationship, this would have been like a contract for service because it said they were self-employed, didn't have mutuality of obligations, so there was no ongoing right to offer and accept work from both parties, which is usually the case for self-employed subcontractor contracts. And it also did allow for substitutions. So that's quite interesting because it did have two of the clauses which would point towards being a self-employed contractor. When it went to the Court of Appeal, this is where they really set this principle that the parties in that relationship don't have equal bargaining power. So the courts and tribunals shouldn't look at what's written down. They should actually look at the reality of the arrangement. And when they looked at that reality, they came to the decision that they were workers. There was a lot more debate, but eventually it did actually get appealed all the way up to the Supreme Court. And they upheld the decision that they were workers, and they held that they were entitled, that the documents did not reflect the true agreement. And the kind of things they looked at, which I think is quite important to pick out what it is in practice that pointed towards being a worker and not self-employed, were things like they did have no contractual obligation to attend work. So it did say written down that they don't need to attend, can work as and when, but in practice, they were totally expected to attend work each day. And they did have that clause that said you don't need to come, you can subcontract it to someone else. But if they actually done that in practice, that would have been considered really strange and not the done thing. So again, they look at the reality, not what's written down. And again, I mentioned how they didn't have control over when they worked or the deductions that were made from their pay for insurance. And they agreed that that was a sufficient degree of control, and that this wasn't a true self-employment relationship. Another case is Pimlico Plumbers Limited against Smith, which again is a leading case in this area. And in this case, plumbers provided plumbing and maintenance services, but they were engaged by Pimlico as self-employed contractors. The claimant who actually raised this claim didn't agree with this and believed that he was an employee. So going from the category with the least employment rights to the most is what he believed. And he believed he should have had sick pay, holiday pay throughout his time working with Pimlico. This case, again, I urge you to read it, but it got appealed all the way up to the Supreme Court, and ultimately they did decide he was a worker. But I just wanted to discuss the types of things that they looked at when making this decision. So they considered control again, as we discussed, that's important. And they actually looked at, they wore a uniform, they used vans that had company logo on them, and we had to use those. He worked specified hours, and they agreed there that that was enough control, not to be self-employed and is more in line with being a worker. There was nothing in the contract which gave an express right of substitution, so said someone else could come in and do the work. There was something in it about swapping shifts and making it easy to do that, but the Supreme Court said that that wasn't significant enough to be recognised. So ultimately, there was operational and financial control, including how much would be paid, restrictive covenants, which would be usually seen in an employment contract, and the actual written agreement. So they held that he was a worker. So not quite the employee that he believed, but more protection than a self-employed contractor. And also, when I was just speaking there about the written agreement, it was interesting that the fact they used words like wages, gross misconduct in the contract, the judge actually did mention these words are really in line with an employment relationship. It's not words that you would see in a services contract. So interesting to look at the type of language used. And the last case is Uber against Aslam, and this was going through the courts when I was at university, so I could probably recite this. And this was a big case that came out that was brought with an Uber driver, and a dispute came around because they are engaged on a self-employed basis with Uber, but they believed they were actually workers. And in the end, it was discussed, and they said that worker status is a test of statutory interpretation rather than contractual. And the legislation around employment status was brought in to protect vulnerable individuals from being exposed to sham agreements and having their rights taken away by these sham agreements. So therefore, the more control, the more likely it is to be a worker. That was the kind of discussion there. So factors here that were considered were the fact that Uber dictated the fare charged for the various rides. They imposed contractual terms on them. They constrained the driver's choice to accept or decline rides. So I think there's some sort of penalty or implication if you decline rides. There's restricted communication between drivers and passengers. And Uber exercised significant control over the way in which drivers provided the services. It was very organised. You had to use their app. There was a lot of rules in place. So that was the kind of factors that fed into the discussion. And they held that when looking at this, they weren't self-employed. They were workers, and control was a big thing of that. And that was agreed by the Supreme Court. And I think these cases are coming up more because we have the rise in the gig economy and more workers wanting to work in these gig economy roles that are more flexible. It might be suitable for students. So we're seeing more case law be generated, particularly with these types of companies. So just some key points and what I think's important to take away from today. As I say, this is a big area, and each of these areas or cases you could do like a full hour-long session on, but hopefully it gives you enough to go on and consider and maybe do a bit further reading if it's of interest. So I think important to have your contracts, have contracts that actually reflect the reality of the relationship. So don't have a term in there that if they actually acted on that term would be very strange and not acceptable. If that's the case, it likely shouldn't be in that contract. So just make sure it reflects the reality. As well, an important one, because I see it in contracts all the time. You agree you're not an employee. That's not a complete defence. If there's any dispute over employment status, it's going to be looking at the true nature of the relationship between the parties. It's not going to be determined by that sentence that they've agreed to or signed. Look at the level of control that you have over contractors and have a think about it. Do your contractors wear uniform with your company logo? How closely do you monitor their work? Do you provide them with their equipment, or do they bring their own? And it's interesting to just have a think about this and whether or not the arrangements you have with your contractors are more in line with what we've discussed today. Or do you think it could be creeping the other way? It's just important to keep that under assessment. Again, if you've got a contractual right, make sure it's genuine. So if you have within your contractor agreements that they can subcontract out that work, someone else can come in and do it, make sure that it's genuine and that they can actually rely on that. Consider mutuality of obligations. Is there an expectation that you'll provide work and an expectation that they'll perform it and ongoing in your agreements? And this idea of just keeping all of this under regular review. If you're an organisation that readily uses contracted agreements, just keep these under review. Make sure that they're still reflecting the reality. And again, if you're ever uncertain, is there an area that I would advise seeking advice on? And I went on, I was just finding this, I went on the UK government website again. As I say, they have a useful kind of web page of advice for employers, and they gave some key points of how to kind of have your contractor agreements in a way that's less risky, and is going to ensure that they are actually truly self-employed. And it said things like ensuring they have the absolute freedom to carry out their own work in their own hours, absolute freedom to choose whether to accept or reject work. They can set their own fee or price. They can genuinely market their services and work for third parties, unfettered right to provide a substitute and to carry out the work, freedom to use their own equipment. So if you have agreements with self-employed contractors, this is the kind of best practice and what you would expect to keep into that agreement. So that is us for this morning's session. Apologies, I've went 5 minutes over. I think I was a bit ambitious with what I was going to cover in 20 minutes. If anyone has any questions, feel free to just turn your camera and your mic on or pop them in the chat. Yeah, Hazel, I'll get these slides sent out to everyone who signed up this morning. Thanks all. So I think if we've no questions, then that'll end our session today.
Thanks very much, Amy.
Thanks very much.
Thanks, Amy.